Under Chapter 3 of the BNS 2023, a person can commit an actus reus, like stabbing someone, and still walk free. This happens when the law grants the defendant a strict shield of criminal liability. This shield is rooted in incapacity. If an individual is a child under 7 or intoxicated against their will under Section 23, the law recognizes they physically cannot form the necessary criminal intent. Section 22 extends this logic to acts committed by a person of unsound mind. Because this condition prevents the formation of intent, it serves as a common baseline test in law exams. Let's evaluate a classic application. Here is question 3 from an exam paper, featuring Ravi, a 35-year-old man who stabbed his neighbor. To determine if Section 22 applies, we must isolate the medical facts. The prompt explicitly confirms Ravi has a history of paranoid schizophrenia and acted under a specific delusion about his neighbor being an alien. That clinical diagnosis triggers the legal standard. Part A of the prompt asks us to evaluate if Ravi was incapable of knowing the nature of the act. That exact phrase is the statutory requirement needed to invoke Section 22. When a fact pattern demonstrates an absolute incapacity to understand an action or its legality, the shield holds firm. Criminal liability is entirely negated. Section 19 covers necessity. Take the ship captain's dilemma. A captain must choose between hitting a large passenger boat or a smaller one. The law excuses causing the lesser harm if it's done without criminal intention and in good faith to prevent a greater disaster. Section 32 covers compulsion. This applies when the threat is directed at the defendant personally. If someone holds a weapon to your head, forcing you to assist in a robbery, the shield protects you. Examiners heavily test the limits of this specific defense. Looking at the text of Section 32, the compulsion shield immediately fails if the forced act is murder or an offense against the state punishable with death. When the shield reaches its limit, the law offers the sword, the right of private defense under Sections 34 through 37. This right is governed by a strict, absolute boundary of proportionality. Consider this scenario. If a pickpocket grabs your wallet and begins running away, are you legally justified in shooting them in the back to retrieve your property? No. Under Section 37, using deadly force to stop a simple property theft is disproportionate. Firing that shot violates the boundary, nullifying the defense and making the victim the criminal. Applying the sword correctly requires mapping specific crimes to the right thresholds. Sections 38 and 41 dictate when deadly force is permitted, while Sections 39 and 42 strictly limit you to non-deadly force. The threshold for deadly force is only crossed during extreme crimes. The statute specifies threats like death, grievous hurt, rape, robbery, or arson. For lesser offenses, Sections 39 and 42 restrict your defense. If you are dealing with simple theft or basic trespass, you are permitted to use physical force to protect your property, but you cannot kill. The law defines the exact timeline of your defense. Sections 40 and 43 state that your right commences the moment a reasonable apprehension of danger arises, even if the physical attack hasn't started yet. But the second that danger passes, for instance, if the attacker drops their weapon and flees, your right instantly ends. Any physical force used after that point is classified as retaliation. Navigating Chapter 3 of the BNS 2023 requires systematic evaluation. Check the facts for clear incapacities to apply to shield, and measure the exact severity of an attack to wield the sword. Answering situational questions correctly relies on identifying the precise threshold crossed in the prompt. Pinpoint the statutory limit, and the legal outcome is clear.